I'm not sugarcoating anything, and that's why I'm also not leaving out today's topic. UK citizens who have retained post-Brexit rights as legal residents of EU member states have encountered problems when transiting Schengen states on their way to the member state where they reside, according to the European Commission, including being wrongfully detained whilst transiting through the Schengen area. The European Commission raised the issue in a document circulated to member states in mid-July, which refers to UK citizens who are legally resident in a Schengen state, visiting another Schengen state, and being detained by the police because they did not have a valid residence document to prove that they are legally resident as withdrawal agreement beneficiaries in their host states. And the document says about this: withdrawal agreement beneficiaries have their previously exercised free movement rights, which they enjoyed as EU citizens, grandfathered only in their host state. With regard to movement in Schengen states or other than their host state, they are to be treated as third country nationals legally resident in that host state. But why did they bring this issue? In 2022, there have been a few cases of UK citizens which were beneficiaries of the WA who have encountered problems when transiting Schengen states on their way to the member state where they reside. The Commission received reports according to which persons who are withdrawal agreement beneficiaries in a Schengen member state entered another Schengen member state for a short stay and were detained by the police because they did not have a valid residence document to prove that they are legally resident as withdrawal agreement beneficiaries in their host states. These incidents have been followed by the Specialized Committee on Citizens' Rights, gathering both UK and the community. In a nutshell, beneficiaries of the withdrawal agreement can use their residence documents issued under the withdrawal agreements, as well as other means of evidence at the border, to prove their residence status and connected rights, such as not being subject to the maximum duration of stay of up to 90 days and a 180 days period in their host state. Beneficiaries of the withdrawal agreement can use their residence documents issued under the withdrawal agreement, as well as other means of evidence at the border, to prove their residence status and connected rights, because otherwise somebody would say it's 90 days, you have to go home. In the first case, the beneficiary was in possession of a registration certificate for EU citizens issued by the host state, and which is included in Annex 43 to the Practical Handbook for Border Guards as a document that the host state still considers valid for the withdrawal agreement beneficiaries. However, the host states had not notified the title of the document for inclusion in Annex 22 of that book. In the second case, the beneficiaries entered the other Schengen member state shortly after the previously issued free movement residence documents lost their validity for the purposes of that book. And the host state had also not notified the title of the documents previously issued to UK nationals for inclusion in this annex, but only the titles of the documents previously issued to non-EU family members. So there were some paperwork issues. And the Commission recommends that all beneficiaries of the withdrawal agreement obtain the appropriate residence document under the withdrawal agreement in their member state of residence, and to proactively present it to border guards when crossing a Schengen external border. My friends do the same. They are residents in the UK and are Germans. First, the best option to avoid similar situations would be for beneficiaries to request and for the host state to issue a residence document under Article 18 of the withdrawal agreement before the beneficiary travels to another Schengen state, as recommended by the European Commission in several occasions. Beneficiary means UK citizens, by the way. The withdrawal agreement residence document will evidence that the holder is legally resident in the Schengen area in accordance with Article 21 of the Convention implementing the Schengen Agreement. And secondly, withdrawal agreement beneficiaries who reside in host member state with constitutive schemes can use their certificates of application to prove their residence status and connected rights as long as they have not obtained a final decision on their application. Member states that operate a constitutive residence scheme under the withdrawal agreement should therefore ensure that they have notified the title of the certificate of application issues. And withdrawal agreement beneficiaries who reside in host member states with declaratory schemes can use residence document issued under the EU Free Movement Directive before the end of the transition period as proof of their withdrawal agreement beneficiary status, provided that there is no indication that they no longer reside in the host member state. For these cases where the withdrawal agreement beneficiary will have to travel before being in possession of a withdrawal agreement's residence document, the withdrawal agreement host state should check whether it has provided specimen of all previously issued free movement documents, which it still considers valid for withdrawal agreement beneficiaries. I know this is complicated. In addition, it's important to note that withdrawal agreement beneficiaries who reside in host member states with declaratory schemes can use other documents that credibly prove that their holders exercise the rights to move and reside freely in the host member state before the end of the transition periods and continue to reside there. Documents indicating the address of the person can show continued residence after the end of the transition period. And border guards may ask questions about the domicile in order to establish the residence status and connected rights of the traveler. And third, as a fallback solution to tackle comparable incidents, is recommended to competent authorities, that means border guards of second member states, to ensure that the individuals concerned are afforded the opportunity to rebut the presumption of their illegal stay on the territory of the second member state and to regularize their short-term stay in the second member state by means of obtaining an entry stamp or record as provided for in that provision. In addition, the competent authorities could issue just a standard form. Such regularization can take place on the basis that the individuals concerned are interrupting their long-term stay under the withdrawal agreement in their home state and starting a new short-term stay during their presence in a second member state, even if it's just for transit. Alternatively, those member states which dispose of other provisions under national law which allow them to consider the stay of UK nationals on their territory as legal, even if not all conditions for a short-term stay are fulfilled, are encouraged to use these provisions for tackling comparable situations. On February 1st in 2020, the United Kingdom withdrew from the European Union. On the same day, the withdrawal agreement entered into force, and it provides for a transition period during which EU law on free movement of person continues to apply to and in the United Kingdom as if it were still an EU member state, and to the benefit of UK nationals as if they are still EU citizens. The transition period ended on December 31st in 2020, and UK nationals who resided in an EU member state in accordance with EU law on free movement of persons before the end of the transition period and who continue to reside there are protected by the withdrawal agreement as of January 2021. The same is true for the family members of these UK nationals, regardless of their nationality. The guidelines aim at helping border guards understand the main difference between the two implementation schemes that member states use with regard to the citizens' rights part of the withdrawal agreement. Based on the main difference between the two implementation schemes I mentioned earlier, the guidelines give concrete guidance on how to identify who is a withdrawal agreement beneficiary for the purpose of not stamping their passport when they cross an external Schengen border. And the guidelines also deal with the border procedure aspects for withdrawal agreement beneficiaries, such as those related to refusal of entry alerts in the Schengen information system. Regardless of the implementation scheme, there are some basic rules for the treatment of withdrawal agreement beneficiaries at the external Schengen borders as well. The passport of a UK national or a family member must not be stamped if they hold the withdrawal agreement residence document. In case of doubt about whether a UK national or family member is a withdrawal agreement beneficiary, the passport must be stamped though. The withdrawal agreement provides that the new residence document has visa exempting effect only for entering and exiting the host member state. In accordance with the Schengen Acquis, the new withdrawal agreement residence document has visa exempting effect in the Schengen area where it was issued by a Schengen state fully applying the Schengen Acquis. As a principle, persons legally resident within the Schengen area shall not be included in the entry-exit system and the European Travel Information and Authorization System. Therefore, withdrawal agreement beneficiaries shall not be included in these two systems. And the EU issued more practical instructions over time about the application of those systems. In general, traveling between the UK and the EU became more complicated after Brexit for a number of reasons, not only if you're already a resident in one of the EU states. British citizens now need, for example, a valid passport that is not older than 10 years and must be valid 3 years still when they leave the EU again. That is just an example I'm bringing up again because it happens still to a lot of people that their passport is so old, and that's whenever I'm trying about residency in the EU or traveling to the EU, I bring this up again because a lot has changed with Brexit, because the EU is a third country now. But I know I put a lot of complicated stuff in this video, and I did this on purpose because I wanted to show that the EU is going quite a long way to make this as easy for the UK citizens that were residing in the EU before Brexit as they can, and they give a lot of these instructions to the member states. Some member states made mistakes, and of course they were teaching border guards, they were changing documents, and I told you about this instruction book, but they are all human and some mistakes happen, and sometimes a document was not added on the annex list as it should have been. But overall, it works very smoothly, and what I wanted to show you with this video as well, there were these cases and they shouldn't have happened, but the EU is doing a lot to prevent situations like this. And if you want to know more about Brexit or UK politics, the next video is right here in the end screen. I'll see you there. I'll be back.